Welcome to the Center Collaborative, Creative Solutions in Behavioral Health and Criminal Justice, brought to you by the Oregon Center on Behavioral Health and Justice Integration, which is also known as the Center. We at the Center are all about solutions. Our job in Oregon is to facilitate improvement of the system so behavioral health and criminal justice can work better together to engage people in treatment while promoting public safety. I am your host, Chris Thomas. I hold a master's degree in clinical psychology and have focused on the intersection between behavioral health and criminal justice for 20 years. Over 7 of those years were behind the walls of a maximum security prison. During this podcast, you will have the opportunity to sit in on real, in-depth conversations with experts about complex topics in a way that is both fascinating and digestible. We will focus not just on what is wrong with the system, but what is going right and how we can work together to evolve. Judge Wolke is speaking within his capacity as a judge. He is not speaking on behalf of the Oregon Judicial Department. On today's episode, I am joined by Judge Pat Wolke, Josephine County Mental Health Court Judge, co-chair of the Workgroup to Decriminalize Mental Illness, and member of the Chief Justice's Behavioral Health Advisory Committee. We discuss his work to strengthen the pathways into the civil system as a diversion from the criminal justice system, particularly in regards to civil commitment and assisted outpatient treatment, also known as AOT. We talk about what AOT looks like and how it can be useful as a possibility in the civil process. We discuss the connection between the difficulty around the civil process and the current fitness to proceed numbers in Oregon. We also talk about the importance of mental health courts in changing people's lives while supporting public safety. I enjoyed our conversation. I learned a lot about assisted outpatient treatment. I think that you will enjoy it too. Welcome to our conversation. Judge Wolke, we are really happy to have you here with us today. Thank you so much for joining us.
Thanks for having me, Chris.
So I don't know if you're comfortable telling the story, Judge Wolke. I know that you have some experiences in your life that really motivated you to get into the work with folks with behavioral health concerns within the judiciary. Is that something that you would like to talk about?
You're right. My son, Billy, who is a brilliant kid, was having a great life, was in the National Honor Society, had a lot of friends, et cetera, et cetera. He was admitted to the University of Oregon Honors College and was in his second term there and experienced a psychotic break and was unable to continue there. He's brought home. He was experiencing psychosis. My wife and I were ignorant as a post about that type of serious mental illness and didn't know what was going on. But ultimately, we determined that it was schizophrenia. He had to go through the civil commitment process, which got my focus really, 2020 on the civil commitment process, because people were telling me he didn't have enough going on to be eligible for civil commitment. And I couldn't believe it because he had had so many episodes that were so frightening and so scary for us and dangerous to him. And so I thought, why in the world could he not be civilly committed? And that got me interested in the law and so on. Ultimately, he was, by a very narrow margin, he was civilly committed. As a result of that, he started taking medicine, and he's been successful ever since. Successful in that he is disabled. He receives disability payments, but he's happy, stable, living on his own. And so that, among other things, got me to be a believer in the civil commitment process, because I believe that had the law been so steep that it wouldn't have applied to Billy, Billy would be like, or could be like so many other people, really wonderful children that develop this type of illness, that all of a sudden they're committing crimes, they're using drugs and alcohol to hide the symptoms. And in Billy's case, that didn't happen because of civil commitment. But I think many, many times I've talked to a lot of parents who know my story. And unfortunately, many of them have not had that type of success with their children because nobody could touch them. They were adults. They could do as they pleased. They didn't qualify for civil commitment. And that can really cause things to go downhill quick. And because it was such a close call in Billy's case, when I thought it was so obvious and so clear cut, that got me interested in the whole issue of civil commitment and serious mental illness. And so it was about probably 3 or 4 years after that I became a judge, and maybe 3 years after that I started the mental health court, and then I worked to get AOT passed in Oregon, and continue to be involved trying to get civil commitment to be a little more realistic for people.
I'm glad that he's doing well. And I really thank you for sharing your story, because I think it gives wonderful context to why this work is so near and dear to your heart.
Yeah. And initially, Billy said, I don't want anybody to know, but after about 2 or 3 years, he said, okay, Dad, you can talk to other people about it and mention what I've gone through. And so for example, when I testified in the legislature, I told them about my son's experience with civil commitment. And he's a big supporter of all this effort that I'm involved in.
Yeah, I think that by telling your story, that context, and I thank Billy for that too, because I think sometimes that gets lost in the conversation, and the worry about what could happen takes over. And so being able to tell your story about watching what happened with your son and how scary that was, and how close a call it was on whether he was going to be civilly committed and getting help, because he wouldn't have chosen to otherwise. And now he's doing well. And what could have happened is such a powerful, powerful story.
And it really has caused me to have empathy for people that develop serious mental illness. Of course, they've done absolutely nothing wrong to have it. They get it. And I have a lot of empathy for parents that have gone through or are going through, what my wife and I did, which is absolute, probably the low point in our lives. But it's had a happy ending so far.
I'm so glad to hear that. What great work you have done, given what you have gone through, and what your son has gone through, is a huge testament to your family.
Thank you, Chris.
Could you give me more detail about your legislative work for assisted outpatient treatment and civil commitment? You explain that so much better than I do.
I started with the legislature back in 2012, and I worked with others to get our first assisted outpatient treatment law passed. And so it became effective in 2013. And you'd find it in the statutes under ORS 426.133. And since then, it's not used that much for some reasons that we can talk about later. Apart from that, I am the co-chair with Senator Prozansky, as you mentioned, of the Workgroup to Decriminalize Mental Illness. That started in the fall of 2017. It's made up of a whole lot of stakeholders. We have people from NAMI, we have people from the Treatment Advocacy Center, we have people from the Oregon State Hospital, the Judicial Department, the Justice Department, the Oregon Physicians Psychiatric Association, ACLU, Disability Rights Oregon, and we just have a lot of other individuals that are interested in trying to do better for the seriously mentally ill. And so that work group has been meeting, probably about every 6 weeks to 2 months ever since the fall of 2017. And in the 2019 legislature, we proposed a couple bills that didn't make it. One was Senate Bill 763, and that was an attempt to define within the civil commitment statute what it meant to be a danger to self or others. Because currently, as you may know, the criteria for civil commitment in Oregon is that you have to be a mentally ill person that is a danger to self or others, or unable to provide for their basic personal needs. And so that's all it says about danger to self or others. It doesn't define what the term means. And so Senate Bill 763 was the work group's attempt to put more definition in the statute of what it means to be dangerous, because as you can imagine, everybody has a different idea about what is dangerous. For example, I think smoking cigarettes is dangerous, but that certainly will not get you civilly committed. And some people think jaywalking is dangerous, but that will not get you civilly committed. So really what it comes down to is whether or not you're dangerous enough to be civilly committed is a matter of case law. It's not statutory law, because the statute is kind of silent on what it means. And Senate Bill 763 was our attempt to define what it means to be a danger to self or others. We also worked on other issues. We work on assisted outpatient treatment, trying to make that a remedy that can really be used within the state. One problem with assisted outpatient treatment is that there's a clause in the statute that says that if a county mental health department feels that they do not have enough resources to do an AOT program, then they don't have to. And when I say AOT, it's an abbreviation for assisted outpatient treatment. And so not too many assisted outpatient treatment going on in Oregon. We also proposed a bill that would extend the pre-hearing detention period. When a civil commitment is started, you have to get to a hearing within 5 days, or else the petition can be dismissed. The plus side is that we want to get an alleged mentally ill person's rights adjudicated right away, promptly. So if they're not being held properly, they can be released. The problem with that is that the mental health professionals indicate that oftentimes if they have a longer period of time, and if the person who starts out in crisis agrees to take medicine that they've either been prescribed or can be prescribed, that oftentimes in a matter of 15 days, they can be clear. And so there's no need to go forward with civil commitment or anything like that. And neither of those, the bill to extend the pre-hearing detention period didn't get out of committee. And the Senate Bill 763, which defined the terms of danger to self or others, did get out of committee, but at the very last minute, the Oregon Health Authority attached a physical impact statement to it that was, in our view, pretty high. It was 9.3 million over 18 months. And so it went to the Ways and Means Committee and it didn't go further than that.
What would you want our listeners to know about the existing civil commitment laws and why we're trying to put through legislation to change them some?
What I would like people to know is that the civil commitment laws really are not doing the job that they should be doing. People that, let's say, are not dangerous to self or others and are able to provide for their basic needs, so they wouldn't qualify under the current law. At the same time, they could be totally in crisis. They could be suffering from a serious mental illness. They could be unmedicated. They could be psychotic. They could be living in a hovel. They could be doing real odd things that gets them in trouble with the police and with their neighbors. And those people we can't really touch with civil commitment because that's not the way our law is written. Other states around the union do address things like that. For example, in Ohio, the statute says you can be civilly committed if you would benefit from treatment in a hospital for mental illness and is in need of such treatment as manifested by evidence of behavior that creates a grave and imminent risk to the substantial rights of others or to the person. So when we started out on this process in Oregon, it was a result of a Supreme Court case that was really kind of horrendous. And that was O'Connor versus Donaldson. It's a 1975 Supreme Court case. And it was really important in that it caused all the states and all 50 states to rethink their civil commitment statute. This was really a very bad situation because Mr. Donaldson was able to take care of himself. He wasn't dangerous, but he was suffering from schizophrenia. So they had a hearing in Florida, and the evidence of the hearing was two medical professionals saying that this person suffers from a serious mental illness. For that reason, poor Mr. Donaldson was committed at the Florida State Hospital at Chattahoochee for 15 years. And he kept saying, I want to get out. I'm not dangerous. I can take care of myself. He had friends on the outside saying that they would sponsor him. They would make sure that he did the right thing and so on. But the superintendent there, who's Mr. O'Connor, kept refusing to let him out. So a lot of problems with what was going on. First of all, Mr. Donaldson didn't have an attorney at the hearing. He's a mentally ill person, and he didn't have an attorney. The discretion as to whether or not to let Mr. Donaldson out of the mental hospital was totally up to the superintendent. There was no review hearings like there are in Oregon. In Oregon, you can only be committed for 180 days. And if the state wants to commit you further, you get another hearing with a lawyer and so on. And then the final thing, he was just kind of marking time there in the state hospital. He didn't get any treatment. So finally, Mr. Donaldson sued the state of Florida, and he sued specifically Mr. O'Connor, who was the superintendent. And at the trial court level down in Florida, he was ultimately awarded damages and punitive damages against the superintendent himself. The case went all the way up to the Supreme Court. The Supreme Court said, henceforth, you cannot civilly commit somebody unless they're a danger to self or others, or they're unable to provide for their basic personal needs. And so it wasn't enough just to be a mentally ill person. If you're a mentally ill person and if you don't want to do treatment, and if you're not harming anybody, and if you're able to take care of yourself, then you're not going to be civilly committed. And based on that ruling, states around the country quickly revised their civil commitment statute, as we did in Oregon. And in Oregon, we basically took the language out of that Supreme Court case saying you can't be civilly committed unless you're a danger to self or others, or unable to provide for your basic needs. And that's what we've had for 45 years. And the problem, as I mentioned, is that there's just no definition of what it means to be a danger to self or others. The other criteria, the basic needs criteria, was interpreted by our Court of Appeals as meaning a person is subject to a basic needs commitment. This is State versus Bunting, a 1992 case. A person is subject to a basic needs commitment under ORS 426.0052B if clear and convincing evidence demonstrates that due to the mental disorder, there's a likelihood that the person probably would not survive in the near future. So that criteria basically was saying you can't be civilly committed under the basic needs criteria unless you're about ready to die because of your mental illness is causing you not to provide for your basic needs. The 2015 legislature thought that was a little too high a bar, and so they modified the statute, or that portion of the statute, to say that you don't have to be about ready to die, but you have to be about ready to suffer personal harm, serious physical harm, because you're unable to provide for your basic personal needs. The other prong of the criteria, the danger to self or others, has never been changed since the mid-1970s, and that's what our work group is working on.
So there's a big disconnect about what we are finding with the law and then what that ends up looking like when we operationalize that with folks who are experiencing severe symptoms. Do you have some examples of where that disconnect is? What kind of symptoms and condition that folks were in, but they still didn't reach the level for civil commitment, and what ended up happening?
I do. If you go through the civil commitment cases from the mid-70s to present, you'll find case after case that, in my view, imposes a very, very high bar for a person to be civilly committed. An example, and there are many, is State versus AMR, and that's a 2010 case in the Court of Appeals. In that case, officers were called to the Junction City boarding house where a woman was arguing with others. When she encountered police, she accused them of wanting to shoot her and use her for target practice. When the police attempted to take her to the hospital on a police officer hold, she resisted and was ultimately placed in handcuffs. She kicked at officers and tried to spit on them. During transport, she had to be hobbled and the spit hood was placed over her head. Clearly, this woman was suffering from a psychotic episode and was unwilling to seek voluntary treatment. Her commitment was overruled by the Court of Appeals. The court wrote, the state had the burden of proving by clear and convincing evidence, and that's kind of a higher burden than a typical civil case, that appellant is a danger to others. As our cases have repeatedly emphasized, the standard is a rigorous one, requiring that the state present evidence that is of extraordinarily persuasiveness, in which it makes a fact an issue of highly probable. The court went on to write that dangerousness can be proven by prior history so long as that history clearly forms the foundation for a prediction of future dangerousness. And that, Chris, that is a term that is used in many cases on the dangerous prong, that it's got to be, the conduct has to be such that a judge can predict future dangerousness. And that's kind of a bone I have to pick with the case law, because I think most mental health professionals would say that predicting future dangerousness is a crapshoot, And in fact, in Texas, where they have the death penalty statute, that's one of the criteria for imposing the death penalty. And the American Psychiatric Association has said that's not something that psychiatrists should be doing. And yet we ask trial judges that just hear, snippets of the facts of this person's life to predict whether they're going to be dangerous. And the prediction has to be that the dangerousness has to be imminent. In other words, right away. And if that bar can't be met, then the person doesn't qualify for civil commitment. And that would apply to people who are, threatened suicide, attempted suicide, people that have threatened to harm their parents or whoever, their loved ones, or they, say they're going to shoot somebody. It's got to be something imminent, and the trial court's got to be able to say that, yeah, I can predict that this person is really going to do what they're threatening to do. That's hard to do.
That is incredibly hard to do. My understanding with the grave disability piece, that has to be pretty significant as well, that the person is facing imminent death within the next 24 hours, which seems like a really high bar.
It is. And let me just tell you about some other states so many states have a similar criteria to Oregon: danger to self or others, unable to provide for your basic needs. But many other states have added new criteria to that kind of takes into effect the people that I think that we should be paying attention to. For example, in Oklahoma, they have a gravely disabled standard. So in Oklahoma, you can be committed if you're a danger to self or others or unable to provide for your basic needs. But you can also be committed if the person is in a condition of severe deterioration such that without immediate intervention, there exists a substantial risk that a severe impairment or injury will result to the person. And then in Washington, you can be committed if you're gravely disabled. Gravely disabled is defined as the person manifests severe deterioration in routine functioning, evidenced by repeated and escalating loss of cognitive or volitional control over his or her actions, and is not receiving such care as is essential for his health or safety. And so even with this new additional criteria, you can see that there's still a high burden of proof. People that are just mentally ill, maybe they're psychotic, maybe they're acting pretty odd, they're not going to be civilly committed. It's got to be above and beyond that. And in the gravely disabled, it's essentially a person that doesn't meet other criteria, but their life is just dissolving and there's a need of intervention.
Are there any statistics around what ends up happening with folks in Oregon who, in other cases in other states, they would have been civilly committed, but in Oregon, they do not reach the bar? What ends up happening with folks? Do they end up in the criminal justice system? I know there was a case where a woman died in a really, really cold winter, but she would not have reached the bar for civil commitment. Do you have anything around that?
Unfortunately, not. But I'll tell you this, Chris: the Chief Justice's Behavioral Health Advisory Committee has a subcommittee on performance data, and Judge Hill from Tillamook County is the chair of that subcommittee. They're doing a great job because the stats around civil commitment have never been very well kept or very meaningful. Judge Hill is really trying to do something about that. He's tracking the number of civil commitments per year in Oregon, which, by the way, are in the neighborhood of about 700 per year in a state of 4.2 million. So you can see it's an extremely rare thing that happens when a person is civilly committed.
So I've sat in on a lot of the decriminalizing mental illness meetings and listened to the conversation. And I know that people become really worried when we start talking about changing civil commitment laws. And so I'm wondering if you could speak to that some.
Well, you're right. In fact, let me just quote the Court of Appeals, what they wrote in 2005. Involuntary commitment for a mental disorder is a serious deprivation of personal liberty and cannot be imposed constitutionally solely to achieve a desirable social goal, such as to provide custodial care for a person until they've reached skills so they can manage on their own. So that's kind of the legal philosophy of the Court of Appeals and probably in general the state of Oregon. There's definitely two competing groups here. One group I would say is in the mode of sometimes involuntary commitment is necessary. It's probably more necessary than it's being used because we just have too many untreated, seriously mentally ill people on the streets that are losing their lives and deteriorating. And there's another group of people, and they're represented in the work group also, as you know, Chris, and they're people that are against anything to do with involuntary commitment. They want to have their voice heard, and it certainly is, and they're against any expansion of civil commitment or involuntary treatment.
When I'm listening to folks talk in the work group, I can definitely hear the concerns and the past, especially around the past trauma of how civil commitment was handled a number of years ago when you were citing the first case,
Hmm.
where it was not a high bar at all for someone to be civilly committed. And it seems like it becomes an alpha versus omega conversation, that the worry, if there's any ground given in involuntary commitment, that it will go back to what it used to be. It seems like it's the meta message that I hear a lot of the time.
Yeah, I agree. But really, when you step back and you look at the stats, which are about 700 people per year in the entire state of Oregon are civilly committed out of a population of 4.2 million, you can see it's pretty rare. And the thought that all it's going to go from 700 to 2,000 or something like that is just not going to happen. There might be a change in the civil commitment laws that would incrementally result in more civil commitments, but it would just be a fractional share.
And when I've chatted with other judges, there's so much worry about folks that come before them that are suffering from significant symptomology, but they don't reach that bar of civil commitment. And they're doing things to come to the attention of law enforcement that are significant. And so there is this rather terrible catch 22 that happens, that folks then end up in the criminal justice system. I've heard judge talk about seeing folks in jail and the state that they end up in, because jail's not a place to treat the symptoms of mental illness.
No,
I think anybody would agree with that, right?
right.
That folks end up in such a state because they end up in the criminal justice system instead of in treatment, and that they don't have the insight to see that they need treatment while they're in the midst of an episode. And I know that you have talked about that before. Folks who don't have insight into that there is something going on with them that they need help with. And so they continue down the same road without seeing that they really need help.
Yeah, I have. It's got a fancy Latin name called anosognosia, which is without knowledge. And it occurs. Now, this is kind of a controversial idea because I believe in anosognosia, and I think most mental health professionals do. And I think people that work with mentally ill people would probably believe in anosognosia. But anosognosia is the fact that through no fault of the person's, through no fault of their own, because they have the illness, a part of the illness takes away their ability to even understand that they're ill. That's called anosognosia, and it occurs about 40% of the people with schizophrenia, a lesser number for people with bipolar. So those people, and I've run into them in court, and any judge has, and that they will simply say, "Why should I take medicine? I'm not ill." And so the notion that those folks are going to at some point engage in voluntary treatment is it's just not going to happen. And another point that you raised, Chris, is that I believe there's a clear connection between a lack of a civil intervention like civil commitment or assisted outpatient treatment and ultimate criminal conduct. Because in mental health court, of course, we take people that have committed crime that are seriously mentally ill. And of course, they don't do that unless they're in crisis. And they typically they're haven't taken their medicine or they don't believe that they're ill, and they engage in criminal conduct, and pretty soon they're in jail, as you pointed out, which is exactly the wrong place for a seriously mentally ill person to be, especially in psychosis, instead of kind of getting treatment within the civil system, the county mental health department, and so on. And I believe that's one reason why in Oregon we have a real crisis now with people who are unable to aid and assist their attorneys. We have a big uptick in those folks. They're the lion's share of the people that are at the Oregon State Hospital, and because of their so many of them, the Oregon State Hospital has been found in contempt because they're unable to move people from the county level to the state hospital as required by other court holdings. Other court holdings say once a person has been found to be unable to aid and assist, they should go to the state hospital within 7 days. Just hadn't happened. It really can't happen because there's just no room at the inn. So they've been found in contempt. They are doing everything they can about it. They've changed the law so that much of the burden on restoration for aid and assist defendants has been passed back to the counties. But I think at this time, we're still kind of in crisis stage. At some point, in some instances, people that are civilly committed and would like to, and it should be sent to the Oregon State Hospital, can't be sent to the Oregon State Hospital because it's so crowded with aid and assist defendants.
That's a piece of data that I've always thought would be interesting to collect in the work that I've done around fitness to proceed. How many folks would have met criteria for civil commitment if our civil commitment laws were different in this state? If there was a different standard, if we looked at other state laws and said this person probably would have been civilly committed well, under those laws, how many folks fall into that gray area? And of course, it's really hard to have the what would happen if data, right? But I really think that that's something that's missing in this conversation. If the laws changed, how many people would fall into the civil commitment track versus the forensic track and all of the other issues that continue down the line when you go into the forensic track. There's not just going into jail. Later on, there's misdemeanors and felonies and the fallout from those, and it can impact your job and your ability for employment in the future. And
Yeah.
so it's a big deal to end up in the criminal justice system. I've always kind of wondered about that, what the data would look like.
Well, that is very topical because in our work group, we're trying to contend with, as you know, we're trying to contend with the physical impact statement that was attached to the Senate Bill 763 in the 2019 legislature. And the Oregon Health Authority said there really wasn't data like that to support that. And there probably is not data like that to contradict that. But just by experience, I see it every day. And kind of the tail end of that and kind of the opposite of that is what they've done in Washington, which says you can be civilly committed if such a person has been determined to be incompetent and criminal charges have been dismissed and has committed acts constituting a felony, and as a result of a mental disorder presents a substantial likelihood of repeated similar acts. So what that's saying is that a person has committed a felony. There's been a question about their ability to assist their attorney. They've been determined that they can't assist their attorney. They're so ill. And so ultimately, because you can't prosecute a person that cannot aid and assist, the felony charges have been dismissed. So they're saying that you can be committed in a situation like that, which is different than Oregon, because in Oregon, they talk about civil commitment for people on an aid and assist who ultimately can't be restored to competency. But you have to go back to the main criteria for civil commitment. At the time of the hearing, they have to be a danger to self or others or unable to provide for their basic needs, which I think is probably an impossible bar because they've probably been at the Oregon State Hospital for quite a while and their basic needs have been taken care of and they're probably not that dangerous at that moment. But Washington just says if you're in that boat, if you've committed a felony, there's an aid and assist. Ultimately, it's been determined that you can't aid and assist, and so the prosecutors dismiss the charges against you. You can still be civilly committed.
I know that in Oregon, there's also been some difficulty around changing paths. So, if someone has come to the attention of law enforcement due to their symptomology and they may meet the level for civil commitment, that some jurisdictions have been having some difficulty navigating from the forensic path over to the civil commitment path, even without what's going on right now with the Oregon State Hospital and not being able to get people in. But before we got to that point, there seems to be a hiccup there in changing lanes. I'm wondering if you could speak to that.
I just don't have any experience that way. At least in our county, I believe that a person that is on the civil commitment track can be identified. They can do the pre-commitment investigation and so on. I have had a case where and I do the aid and assist hearings in Josephine County. I've had a person that could not aid and assist as attorney, but then was committed as a sexually dangerous person, which is a separate type of commitment. So I know that's possible. I don't know why some counties have difficulty with that, but in my previous life I worked in a very small county as a district attorney, and things are just different in small counties as far as resources, as far as expertise. They may not have a prosecutor that understands that there are two lanes and how to go from one to the other. So that is my suspicion anyway.
That's good to know. It really does seem like it differs from jurisdiction to jurisdiction. I know that in places where they have one judge who's doing fitness to proceed, aid and assist docket, and then also the civil commitment hearings, that they seem to have some more success with that than having lots of different people doing all those jobs, because
Yeah.
it is a really specialized piece of the law.
It definitely is, and the current thinking is that that is what should happen. We should have a judge or judges in a big county that's assigned to cases like this, that develops expertise in mental illness, develops expertise in remedies for people with mental illness, and how to change lanes, like you mentioned. And that judge should not only do civil commitments, but should do AOT and should do aid and assist hearings. And that's in Josephine County. That's the way it is. And I think it's that way in most large to mid-sized Oregon counties. But like I say, I came from Gillum County, which is a very small county, and the DA there was part-time. I was that person for a period of time, and I can tell you, I didn't know anything about civil commitment. I didn't know anything about aid and assist to speak of. And so I think it varies from county to county.
From what I'm hearing, it does sound like it does tend to vary quite a bit. Do we want to talk about assisted outpatient treatment a bit? It seems like there's not a lot of clarity about where exactly that fits in the continuum and what that looks like.
Well, let me explain my perspective. The way the statute is written and the way it interacts with the rest of the civil commitment process is that when there's a notice of mental illness and there's an investigation done, the investigator can say, I recommend this person for civil commitment, or in the alternative, I recommend this person for assisted outpatient treatment. And that means in the assisted outpatient treatment law, there is lesser criteria for imposition of an AOT order as opposed to civil commitment. So civil commitment, as we discussed, is danger to self or others and basic needs, interpreted by the Court of Appeals with a very high bar. AOT is that you have a mental illness, you refuse voluntary treatment, you're deteriorating to a point where you could be inpatient civilly committed. And so do go to a civil commitment hearing, just like in any other case. You hear all the evidence, and the trial court judge at that point can say, I don't find that this mentally ill person meets the high criteria for civil commitment, but I do find that he or she meets the lesser criteria for assisted outpatient treatment. So I'm going to order that this person participate in assisted outpatient treatment. And then what happens then is the mentally ill person, his or her attorney, the mental health professional work out a treatment plan. They bring it back to the judge who would endorse it, sign it. That's the order. That's the court order that you do certain things. And the certain things would be like, remain a law-abiding citizen, take medicine as prescribed, engage in other treatment like counseling and so on. And then there'd be review hearings, sort of like there is in the mental health court. Come back to court in 2 or 3 weeks and we'll see how you're doing. A couple of pushbacks on AOT is one, that people believe it's going to cost a lot of money to do AOT. In other words, we're going to have staff, we're going to have facilities and all that sort of stuff. And I disagree. I think that the people that would be in an AOT order would probably be those people that are using services already. In other words, they're mentally ill, they're not doing well. They would come to the attention of the police, they would come to the attention of the jail, they would come to the attention of the mental health department. AOT is merely a way to focus resources to help them. And then you have the oversight of a judge, which in my experience in mental health court, and I think most judges in mental health court would say that's a constructive thing. It's the so-called black robe effect that would impress on people that it's necessary to take the treatment plan seriously. So one pushback from opponents or just people that are not interested in it is it's going to cost money. And I don't think it would cost money because I think all the staff is there to do what needs to be done. Like in some cases, it might involve ACT services, assertive community treatment services. And they're already there, they're already on staff. And the other pushback is, what if the person just thumbs their nose at the order? What do you do then? Well, you can't put them in jail because, as we've discussed, that's just the wrong thing to do with a mentally ill person. So basically, there's no big remedy, a show cause remedy like a probation violation. There's nothing like that. The remedy for AOT around the country is they would just be deteriorating to the point where they would be a candidate for civil commitment. They would go from the lower bar to the higher bar, You start the process over and you suggest at that point civil commitment.
As I'm listening to you talk about AOT, it makes me think of risk and need. So, the need for treatment balanced with the risk to recidivate, to commit another crime.
Yep.
Not dangerousness, but risk to commit another crime. And treatment courts, mental health courts, the research says that we need to concentrate on folks with high risk, high need. So, high treatment need, high risk to recidivate. And it makes me think that AOT might be a great tool for folks who have a high need but don't reach that level of recidivism risk like you would look at a treatment court. So their charges aren't and their behavior isn't to the point where you definitely want to go down the criminal path. You want to go down the civil path, but their treatment need is so high that you want to be able to have the mental health court-esque, having the judge work with them and the treatment team work with them so they have some more structure than a pure deflection or diversion, but that they are still on the civil path. Am I wrapping my head around that correctly?
I think you are, absolutely. And it's, I think when good analogy is what happens in mental health court. Mental health court, of course, is for people who committed crime under the influence of a serious mental illness. AOT is very much like mental health court, except for you don't commit the crime. But as you mentioned, they're people with very high needs, and they're people that need structure. They need, as in mental health court, they need reappearances periodically before an authority figure, and not paternalistically, but just to monitor how they're doing, to talk with them in a respectful way. So I think that's, in my experience in mental health court, that works. It doesn't work all the time, and when we talk about people with high needs and high risk of recidivate, we're talking about people that can very well fail in the system. Something's going to trip them up because they have the high needs and because they have high risk factors. But those are the people that, and oftentimes in mental health court, really turn their lives around. So they go from being repeat offenders, always in jail, always in courts, always in the emergency room, always at the attention of the mental health department, to being people that just go on with their life. And as I always preach in mental health court, you go on with your life, you have a nice, peaceful life. You don't have to worry about police officers anymore. You don't have to worry about a place to be or live or things to avoid. You can just go on and enjoy your life. And oftentimes that happens in mental health court, and it could happen with AOT too.
And we definitely have research around specialty and treatment courts with the relationship with the judge, particularly, but also with the treatment team, how cathartic that is and effective. There's research around how the average time that a judge spends with each participant being 3 minutes or more. That the research is so specific. So when I'm hearing you talk about it's not a paternalistic need, there's actually research to support how important the relationship and structure with the judge and the staff is when we're talking about treatment courts. And I would imagine that it would be like that with assisted outpatient treatment as well.
It would. In both cases, it's different. It's way different than a typical judicial thing because, I call the participants by their first name. We talk human to human as opposed to judge to defendant. And the team is the same way. Everybody understands that every person needs to be respected. They need to be listened to. There needs to be procedural fairness. And so, in a typical mental health court session, I do talk to the defendants for 3 or 4 minutes. I ask them how they're doing with their life, and the team supports them. One of a nice byproduct of our mental health court is the people that are participating in mental health court have formed their own social groups outside of mental health court. They get together for coffee, they get together for pizza, and they call each other up, they text each other, they give each other rides. And that is, as you know, Chris, a byproduct of serious mental illness is isolation. And so it really helps to break down the isolation that many of these people have experienced.
Absolutely. We are seeing more and more that peer support is so important to the recovery process.
Yep.
As we're talking about treatment courts and mental health court in particular, I think that sometimes folks think that it is letting someone off by putting them in a treatment court, that it's an easy road to go down. But from all the work I've done in treatment courts, I've seen it's very much the opposite of that, that there's much more supervision and treatment and onus on a participant in a mental health court than there would be within the usual probation structure.
Absolutely. I mean, we have people in mental health court that commit the small nuisance crimes like criminal trespass or interfering with a police officer or criminal mischief. Those folks, if they merely pled guilty and were sentenced, would be on bench probation with no supervision, and they would probably get maybe 5 to 10 days in jail or other custodial programs, pay a small fine, be on their way. And so they know that. And when they have the option of coming in or not coming into mental health court, they know that their attorney tells them, I mean, if you just plead guilty to this charge, this is what's going to happen to you. If you plead guilty and agree to a probation that involves mental health court, it's going to last for a year. You're going to be required to do a lot of treatment. You're going to be required to stay law abiding, not use substances, report to court, abide by the terms of your probation. And they still elect to do that. Now, in some cases, it's not that way. Some cases, people are avoiding prison by being in mental health court. And so they're on some kind of departure. And if they can't do the program in mental health court and recover, then there's a possibility of going to prison. There's a case that I just got through with where a guy I really liked, really pulled for. He's in mental health court for quite a while, but ultimately got caught using methamphetamine for quite a while and had to be terminated. He's looking at 18 months in prison now. So it can be both ways.
Yeah, it definitely can be. For folks who are considering mental health court, and it would be a lot easier, right? For them to just plead guilty and do the time versus being in a treatment court scenario. How does the court outreach to those participants? Do you have a conversation with them? Does their lawyer have a conversation with them around the benefits of a treatment court? What does that look like?
All of that. So as you may know, the way a person comes into the attention of mental health court is typically through a defense attorney or a probation officer. So we take people that are on probation that have this serious mental illness and are not doing well, and their probation officer says that they really need more structure of mental health court. We have people that have committed new crimes. Their defense attorney talks to them, realizes that they're mentally ill, either through observation or through their own history, and relays that to the prosecutor. And the prosecutor, as with all criminal prosecutions, has prosecutorial discretion, so they can say yay or nay. But our prosecutors are very much in favor of our mental health court. So a defense attorney might say, my guy is charged with assault 4, but he is schizophrenic. And at the time of the assault, he was not taking his medicine and he was hearing voices and so on. So would you consider him for mental health court? And we're getting more and more formal as we go along. We try to get a evaluation that we try to have some really concrete evidence that the person does suffer from the serious mental illness, because that's a baseline criteria for mental health court. You have to have schizophrenia, bipolar disorder, schizoaffective disorder, really serious depression, or service-related PTSD. So if a person is merely depressed and committed a crime, they don't qualify for mental health court. So the defense attorney would relay that information to the prosecutor. The prosecutor say, yeah, I think that it would be better for our community if this person did mental health court as opposed to just got the 10 days in jail and so on. Make a mental health court offer. And that offer may be something like, we'll hold the charge in abeyance. If you're successful in mental health court, we'll dismiss it, or we'll reduce it from a felony to a misdemeanor, or we'll reduce, if there's multiple charges, we'll hold many of them in abeyance. He can plead to one, and that'll place him on supervised probation, and the rest will go away if he's successful. If he's unsuccessful, he's pled to him, then he gets sentenced on those charges too.
This conversation takes me back to when we're talking about deflecting or diverting someone within the criminal justice system. There's multiple points where that can happen, and that should be based upon their need and their risk, right? So to recidivate. So not everything will work for everyone, right? So some folks you can deflect or divert early with crisis work. Some folks you can deflect or divert into a civil track with either civil commitment or assisted outpatient treatment. And others, there is of a high enough risk to recidivate along with a treatment need that diversion or deflection needs to occur farther down in the continuum with something like a treatment court, so that we want to make sure that we've got all these multiple tools that we can access. And right now it seems like we don't have some of those tools in some areas, and some of those tools are a little bit difficult to get to on our belt right now.
Yep. I would contend the civil remedies are unduly hard to get at. And what you're referring to, and I'm sure that you're more familiar with this than I am, is the sequential intercept model, which basically was a very smart idea to suggest that people are involved in the criminal justice system that are doing that because they have a serious mental illness or a mental illness. It would be much better to take care of their illness and get them out of the criminal justice system forever, as opposed to prosecuting, reprosecuting, and so on. And the sequential intercept model starts with the point of arrest and it ends up all the way at post-prison supervision. And at every single intercept, the idea is to get this person out of the criminal justice system forever, get them on some kind of treatment. And what I contend that civil commitment and AOT is, even though they're civil remedies, is the -1 part of the sequential intercept model. 1 through 5 are the intercepts, and the first one is, of course, arrest. The fifth one is probation or post-prison supervision. But I think if we didn't wait to get a person with serious mental illness help when they were already in the criminal justice system, if we did that before they ever got there through effective civil remedies like assisted outpatient treatment and civil commitment, we'd be far better off.
Absolutely. They've actually added an intercept now, Judge Wolke,
Oh,
intercept
good,
0, and
good.
that is exactly what you're talking about.
Yeah.
I like the -1 too. But yeah, intercept 0 before someone's even arrested. Because if there's a lower need,
Yeah.
a mobile crisis might work at that point. A crisis light might work at that point. A co-responder model, working with a CIT trained officer. There's all these other possibilities that could work at 0.
Mhm.
As you so eloquently explain with sequential intercept model, as you move through the intercepts, then you have all these options for diversion and deflection. And what I love about the model is that while we want to make sure that we are diverting and deflecting where we can at 0 and 1, because jailing folks for mental health and low criminality is not a way to get people treatment. Folks just get worse. But as they go through the system, that there's still attention to their treatment need. So if someone does have enough of a concern, like the individual you talked about earlier, who was not successful in the mental health court and ended up having to go to prison, that their treatment need is still being addressed at that intercept and addressed as they're coming back out of the system so they don't reemerge again. And that's one of the elegant things that I love about the sequential intercept model. We really want to focus on 0, 1, 1, and yet we also don't want to forget about the folks that go all the way through intercept 5.
Very good point. Talking about that particular guy who I said I really was pulling for and liked a lot, I know at least that when he does go to prison, they will recognize that he has a mental illness because of his participation in mental health court, and it won't just get ignored. And I know that there's treatment in prison for people with serious mental illness that's better than it used to be, among other things. So, if he needs medication, I think he does, they'll find the right medication and prescribe it. And he will have a period of sobriety, which he also needs.
When I worked for the Department of Corrections at the penitentiary, gentlemen with severe and persistent mental illness were on my caseload. And I worked with a lot of the adults in custody that cycled in between general population and we actually had an inpatient acute mental health unit there at the penitentiary. And those were the folks that I worked with. And then when I became a release counselor, I was the first release counselor in the state that worked specifically with folks who had severe and persistent mental illness and intellectual and developmental disabilities who were releasing, to make sure that parole and probation were prepared and behavioral health were prepared and other services for that person to come out and start right away in treatment, and that the concerns and the needs for treatment weren't just kind of discovered when the person showed up at their office. There was planning that could occur. That was before the expansion of Medicaid. So it was a pretty significant process to get folks their Social Security and Medicaid benefits back then. I know it's gotten a lot better with the expansion of Medicaid in the state. And the DOC is continuing to do that, which is phenomenal.
They are. I see it here at the local level because our probation officer on the mental health court team gets all the information about people being released from prison. In fact, we've had people on post-prison supervision released from prison that come into mental health court because they have all that information that you're talking about, which is extremely important and a good change.
It's all about the collaboration across agencies and across the system.
Yep.
So, for our listeners, what would you want them to really know about the work that you're doing with civil commitment and assisted outpatient treatment?
Well, for years, for 45 years now, we've been super protective of the civil liberties of people with serious mental illness. We've done a great job on that, and we're going to continue to do a great job on that. We're never going to have more situations like Donaldson in Florida. We're never, ever going to happen about that. But we kind of need to rethink or expand our thinking about treatment for people with serious mental illness that, for one reason or another, refuse treatment. And oftentimes their refusal is not based on any of their self-will. It's based on anosognosia, or it's based on stigma, or it's based on just terror of what's going on with them. And nobody likes to impose their will on other people. But I think Oregonians, we need to start expanding avenues that people with the serious mental illness that are not willing to get help voluntarily can get some kind of help. Because among other reasons, there's the RAISE study, response after initial episode of psychosis, which holds and has proven that if a person with serious mental illness can get help right after their first episode of psychosis, their chances of having a good and normal life are so much higher than a person that ignores the illness or won't get treatment for the illness. They get involved in drugs and alcohol, and maybe 10 years down the line, they want to get some treatment. By that time, their baseline is lower, and it's going to probably remain lower because of the delay.
That's such an excellent point. That's why we have the ESA program,
Yeah.
the early intervention for the first psychotic episode. And I definitely saw that working for the department, that with each episode, sometimes it became harder and harder to bring someone back to baseline.
Absolutely. That's a great program, and glad we have it in Oregon.
Absolutely. It's just really about being able to have evidence-based tools and multiple intervention points instead of just trying to find just one, right? So right now, a lot of our conversation is around aid and assist and fitness. I've been in a lot of those conversations on the policy and legislative level, and it's absolutely demanding our attention. It's causing a lot of difficulty in Oregon right now on both the folks that are experiencing it, but also on the court level and at the state hospital and the fiscal level. But if we only focus on fitness, we're ignoring all the things that brought folks to that point. And if we could have intervened so much earlier, we may have never gotten to a competency restoration hearing.
Absolutely right. And as you know, Chris, when it comes to an aid and assist restoration, that's not the same thing as recovery. That is kind of dressing the person up to the baseline so that they can basically understand what's going on in the court. Really doesn't have that much to do with recovery and a program for stability in the future. And as you know, many people that go through an aid and assist manage to get through a plea negotiation and enter a plea, and then they reoffend, another aid and assist, and another aid and assist, and so on. So it would be wonderful if aid and assist meant more than just restoration, competency, if it meant, recovery.
Yeah, that is definitely one of the many drawbacks to the aid and assist process. You're absolutely right. It's only to restoration, which is not a high bar. Even if the person ends up going to the state hospital, the treatment that they receive is very different than the treatment that they would have received through the civil commitment process.
Yeah. Yep. Civil commitment, I believe, is designed at recovery, and that's what mental health court is. That's what AOT should be about, is recovery, getting the person to a point where they won't have to come back into the system, either the criminal system or the civil system.
If we could have programs that we can divert and deflect people into that's focused on recovery before we ever get to the point where we start talking about competency and going that route with fitness, that would make such a huge difference, both for the folks who are going through it and also with the system as a whole.
Yeah.
Well, is there anything else that you would like to share with us today around mental health courts, assisted outpatient treatment, civil commitment?
I know we kind of run in parallel universes. I know that you're doing great things with your various efforts through Gobi, and I'm kind of technically a member of your group, so I never can attend anything because of my court docket, but I appreciate what you do, Chris.
Well, thank you, Judge Wolke. Hey, you are a judge. I know how that goes.
Yeah.
You are ruled by the time of your docket. I totally get that.
Yep.
I appreciate what you do. I really appreciate you coming on the podcast with us today to talk about civil commitment, AOT, and mental health court. There's so many concerns around civil commitment and AOT and worries around it. And so having the opportunity to talk about how they can be helpful tools earlier in the system, I think are so important. And I really appreciate you taking the time to chat with us today.
More than happy to, Chris.
The Center Collaborative is a production of the Oregon Center on Behavioral Health and Justice Integration, a specialized division of Greater Oregon Behavioral Health Incorporated. It is produced by me, Chris Thomas, with production assistance from Patrick Kennedy. Music by Patrick Mulvihill and Patrick Kennedy. Subscribe to the Center Perspective using your favorite app. To learn more about criminal justice and behavioral health in Oregon, visit the Center's website at ocbhji.org. You can also find us on Facebook. We'd love to hear from you. Please reach out to us. Join us next time as we chat with the experts about programs and partnerships at work within this complex and yet compelling field.